Thank you very much for coming to our panel. Wait, where's it? Missing the name of it. Whiteness is Property in Practice, Attorneys of Color in White Spaces. And we have three fabulous panelists today. The first panelist is Mira Bale, who's an associate professor of law at Thomas Jefferson School of Law in San Diego, California. In 2013, 2014, she held visiting positions at Berkeley and at UCLA. She's a JD PhD from UCLA and Michigan, where she was actually one of the interveners, student interveners in the Grutter case. And she will speak today about some of her own originally collected data regarding the experiences of faculty of color with a focus of women of color in law schools. Our next speaker would be Luz Herrera, who's the Assistant Dean for Clinical Education, Experiential Learning, and Public Service at UCLA. Prior to that, she was a Senior Clinical Fellow at Harvard Law School, and she's one of the leading voices in the nation on how to promote entrepreneurial efforts to address the gap in access to civil justice. And she's going to speak today about how the property value of whiteness within a space that we wouldn't normally think of, which is public interest lawyering itself. And then finally, our last speaker is Brian Garth, who's the Chancellor's Chair at the University of California Irvine School of Law. And prior to that, he was a dean at both Southwestern Law School and Indiana University Bloomington School of Law. And he was also the director of the American Bar Foundation. He's authored a number of award-winning books, and he serves on the executive coordinating committee of the After the JD Project, the first longitudinal study of the legal profession. He's going to spend some time speaking about the After the JD Project, and also spend some time talking about some of the structural ways, both globally and internationally, in which people who are part of that structure either become to defend whiteness as property. And with that, I'll turn it over to Mira Bale.
Well, it's not quite noon, so I can still say good morning. It's so nice to be here. I want to thank the organizers for including our panel today, and to thank my panelists. So as the organizer of this panel, I can say it is wonderful to see, to have kind of a reunion with some friends and loved ones here as the speakers themselves, and then to be back at UCLA, where, as Angela said, I did my PhD and I visited in the spring. So I'm feeling very comfortable and at home, and I'm excited to share my research with you. So I think we have about 10 or 15 minutes to present, and I'm going to do some kind of interactive things as we go along as well. The title, as you can see, is different than what you have officially in the program, if you've looked at that directly, which is all to say this is a work in progress. Even the title is changing, so I welcome your feedback in terms of the substance, obviously, as well. So this is a rough sketch of what I'm hoping to cover in our time together. As I said, it is going to be somewhat interactive, and so we're going to start with the interactive parts. If you've participated in this specific interaction with me before, don't volunteer if you already are sure that you know the answers. Okay, so first, what I'm going to be talking about today deals with legal academics. So I am talking, as Angela said, specifically about women of color, but I've included in the empirical sample that I'll get to white women, white men, and men of color as well. So to get a sense of who it is we're talking about, I thought it would be helpful to frame our conversation today with the numbers themselves. So when we talk about women of color legal academics, or when we talk about legal academics as a whole, who are we talking about? So as you can see, we have this handy table here. It comes directly from AALS. So this is not my collected data, my primary empirical research. This is from AALS, but it will help us identify the number of legal academics in the U.S. looking specifically at race and gender. So I've given you the category with the smallest value component. So that's Native American women. There are, as you can see, 21 Native American out of almost 11,000 law faculty members total. So I'll ask for your assistance in helping fill out the rest of the table. So we know what it is for women. What's your guess? You can just shout it out for Native American men. 40, 15, 100. Okay. 30, pretty close. 100 would be, aspirational, I'll say. But the ratio here is generally reflected throughout most of the other categories, not all. So just as a little hint as we continue through our game, African American women, we have 409. So what's our educated guess for African American men? 700, I heard. 475. 600. 650. I know, this is like The Price is Right. Okay, so I think you will all be disappointed. This is the first group for which the ratio does not actually hold true. This is not unique to legal academia. It actually tracks academic outcomes and professional outcomes for African Americans by gender. So I did, by giving you the hint before. So I'll trick you again. Here is the category that will help us understand all other categories, the category with the largest value. So it's just over 5,000 white men in legal academia out of almost 11,000 total. So what's our guess for white women? 3,000, 2,000? 2,500? You're getting very close. You're getting better and better at this. 2741. So this is the second group for which the ratio is slightly different from what it is for the other groups. Here we have almost twice as many white men as white women, so obviously many more white women than other race or ethnic groups with regard to women, but there are almost twice as many men as women. So the ratio is different even though there are many more white women.
Can you just give a definition? Are you at what you're counting as law professors?
Yeah, so AALS tracks everyone who's teaching in law. So, and the next slide will actually be their exact table, but they include everyone who is involved as a law teacher. So which is, a little more dramatic if you think about the 21 Native American women, for example. So it's everyone who has not just a tenured or tenure track position, but also visitors, adjuncts, people on contracts, so every single person who performs as a law teacher. And then finally we have Asian American and Latina women, a little bit over 100. What's our rough guess? Similar for men. 150, 200, yeah. So this is the table that I was just mentioning. This reflects data for the most recent year for which statistics are available. So there are two issues with this. The first is the one we've discussed already, that it includes everyone, not just tenured and tenure track faculty whom we tend to think of when we think of law professors. We know that women of color and other non-traditional law professors tend to be concentrated in the less prestigious areas, even of law teaching, and so I would suggest that they are overrepresented even in this table. The second problem is that we don't have current data. You can see at the top I have the date, 2008 to 2009. That's the most recent year for which statistics are available from AALS. This is my 6th year of law teaching, so I'm not included in the table that I'm studying. So people often say that when I present this data, it's hard to understand because it's a bunch of numbers on a table, so I'm giving you a couple other ways to look at it. Here's one. Obviously, the problem here is you really can't see what's going on for the most part, although I guess that's the point. Here's another one, and this one doesn't include all of the race and ethnic groups. I've just looked at white men, white women, and I've condensed together women of color as the light green slice, and then men of color as the dark green slice. People often ask me, how this compares to lawyers, other types of lawyers, so not just legal academics, but legal practitioners. So just as, I think this is in here, just quickly, here's associates by race and gender. This is from the top 500 law firms. This comes from NALP. Again, this is not my data directly, but just as a point of comparison. So again, here's legal academia, and here's legal practitioners. Now, of course, if you look at the title, it says law firm associates. Once I go on a tangent, I feel like I should commit and go all the way. So just in case you're also wondering, law firm partners. Okay, so perhaps surprisingly, very Few people have looked into these race and gender disparities in the law school context, and nobody's looked specifically at intersectionality, which is the focus of my study on women of color. So there are a few studies that have looked into this over the years. So Richard Delgado and Derek Bell conducted a somewhat informal study and published their results in 1992, showing that there were very few law faculty of color in the U.S., and they had challenging qualitative experiences as law professors. USF also published a symposium drawing from the legal scholars around the country in 1986, so relatively small volume, as you can imagine. Things have not improved much as we get to the next two. Presumed Incompetent is a recent compilation of scholarship looking specifically at women of color in academia across the disciplines. Showing, as you can see from the title, that this presumption of incompetence works against women of color from the time that they enter legal academia, inhibiting their success. And then finally, Elizabeth Mertz and Catherine Barnes have also partnered with the ABF to study tenure and job satisfaction among tenured faculty, and they've identified some race and gender patterns as well. So these laid the groundwork, and honestly, I thought that there would have been other things done before I began my study, so I was very surprised to see that really very little had been done. And so I set out to do a study of my own. The Diversity in Legal Academia study collects survey and interview data from law faculty around the country. There are a total of 93 legal academics who participated in the DLA study. The core sample is women of color, and then I also included, for comparative purposes, white women, white men, and men of color. So when making these presentations to legal academics or practitioners, I'm often encouraged by the organizers to skip the methods and jump into the findings. As a sociologist, I love the methods, so if people are interested in the methods, please feel free to ask me about it, either in the Q&A or I'll be here throughout the conference. But these are the themes we're going to spend the rest of my time on today. We're going to look specifically at barriers to entry and also at barriers to advancement. And with advancement, I'm not looking specifically at tenure. I'm looking at formal administrative leadership positions. I've included just one quick slide on white male contrast, just to show how things might be different for another group. And I always like to, if I can, include some possible solutions for us to talk through as well. So the first theme deals with barriers to entry, the challenges that people of color face when they seek to enter the profession. Many current law professors of color call themselves accidental law professors, people who are not on a clear path to the profession but moved almost by accident into this role, from practicing adjuncts to visitors to tenure-track faculty. Some were encouraged multiple times to apply for tenure-track faculty positions before they actually felt comfortable submitting an application. Many did not think that they had the right credentials or didn't really see a role model when they themselves were in law school, and so did not consider even that this could be a job for them. In addition to these perhaps more internal challenges, there are also more structural barriers, including outright discrimination, especially notably in my sample at least, against Muslim and Arab Americans. The quote at the top, for example, this is a really interesting angle to look at my slide, but the quote at the top is from a DLA participant who was recounting a conversation that happened during a faculty meeting where a group of faculty the faculty as a whole was discussing a candidate, and the candidate was a woman in hijab, and a white male on the faculty said, publicly at the meeting at least, not externally outside of the meeting, but publicly at the meeting that he would not be comfortable with her in the office next to his. So he didn't bring up any challenges to her scholarship or teaching. He just said that he wouldn't be comfortable with her. There's also discrimination against African American, Latino, Asian American, and Native American candidates, so a lot of non-traditional law faculty members. There's also more subtle implicit bias, including the tendency for predominantly white male institutions to reproduce themselves by hiring often other white males with whom they are most comfortable. Now, of course, once you get in the door, the obstacles continue. Many law faculty try to keep their heads down and just get their work done. Others aspire to become leaders at their institutions, but there are barriers to advancement as well. So opportunities today are actually increasing substantially for women of color, people of color, white women to step into formal leadership positions, as existing deans and associate deans are often stepping down from those positions. But few women of color are answering the call. So some say overtly, as this person does, that they would never want to be a dean. When pressed to explain why, some are clear that they would prefer to spend their time reading, writing, working on teaching, and on scholarship. Family obligations also compete for professional advancement for many women of color in legal academia, and especially for women of color as compared to other women, because there tend to be more family obligations than for other groups, as well as fewer support systems. Still, others are clear that they find the job too political for their liking. Now, initially when I was going through and structuring this analysis, I thought many of these seemed like individual barriers, things that individually were keeping individual women of color from assuming those roles. But I think they do have a structural component too, and one that in some ways tracks the barriers to entry. So many of these women of color are essentially saying about leadership what many faculty candidates for entry-level positions have said about academia as a whole. They don't feel like they belong. They don't tend to apply for the positions because they don't see themselves in these roles. And they do see some people who are deans who look like them or have a name like theirs or have experiences like theirs. But often those women of color are not put in a situation where they are likely to succeed. So in this way, I think the obstacles that appear to be individual reluctance actually draw from larger, deeper structural problems that must be changed if we actually want diversity in leadership. Now, I said I was going to show you just a couple contrasts to show how the experiences for white men might be different. So many of the white men who participated in the DLA study saw themselves as law professors from early on and did not face barriers to entry or advancement. So for many, when they were law students, they admired their law professors and they sought to emulate them. Most of their professors were white men, so I suspect they could see themselves at least in those roles. Some of those law professors, when the students were students, right, so 20 years ago or whenever, many of their professors directly encouraged these white male students to consider law teaching as a profession. Others could turn to close family and friends for advice about teaching positions and the job market generally. Now, in terms of leadership, white men were rarely challenged or presumed not to be leadership material. Instead, most were acknowledged as leaders from very early on. This is a dean who participated in the study. He said during the course of our interview that he was in the 7th year of a phased 5-year retirement. So someone who's been in legal academia for a long, long time. And he's someone who had seen himself from very early on as a leader. Well, that one's hard to read. Down the road, I might go for something like that. That's what that one says. That's from a white man in the study who's not necessarily interested in being an administrative, formal leader, but doesn't necessarily see it as something that he would rule out. So again, this is in contrast to the many women of color in the sample who sense they don't belong in leadership positions.
Is the screen down, or will that help, or is it on?
I'm not sure it'll help, but that's the last one that's on this one. Thank you. This is in contrast to the many women of color who just don't see themselves in these positions at all. Now, in terms of solutions, some of these the ones that are on the slide come directly from the participants themselves. So first, hiring committees should utilize out-of-the-box recruiting strategies so that we're not just relying on accidental law professors to diversify the academy. We should build a pipeline, many of the participants said, starting in law school. So law students of color and women law students see themselves as future law faculty members instead of never even considering law teaching as an option. Recruiting should include both formal and informal mentorship. Every single participant who had a mentor in this study was immensely grateful for the benefits. They learned the ropes, the formal requirements of filling out a FAR form, moots for job talks, and the informal unwritten rules of how to get a job and advance as a leader. In addition, administrators must address institutional bias, including implicit bias, in order to make progress. Real commitment means active outreach, not just this abstract desire for diversity. So in other words, don't just hope a woman of color comes your way. Go out of your way to find her. Otherwise, as one woman of color dean notes, faculty and leadership will remain homogenous, and through our inaction, we will have lost the opportunity to complain. So I welcome your feedback and your questions and comments, and I look forward to the rest of the panel as well. Thank you.
We were trying to figure out if we were going to sit or stand, and I decided that I'm too short to sit. So here we go. Good morning. So I'm going to talk a little bit about my own experience in the legal profession as a way to talk about whiteness as property, in particular in public interest lawyering. But my hope is that this is a conversation starter. So not so much focusing on all the specific issues in terms of public interest lawyering, but to really maybe shift a little bit the paradigm in which public interest lawyering is discussed. I went to law school to be a public interest lawyer. My vision of the law was that it was a tool for empowerment. And I didn't know anything about attorney demographics or salaries, but I did know that law degrees do more, people with law degrees could do more for others in their families and in their communities. So I didn't enter the profession thinking that I would make a great deal of money. It was only in my second week of law school that I learned that students graduating from elite law schools could command $80,000 as starting salaries. Well, that was before that jumped, right, to six figures. By the time I was a first-year associate, that salary had jumped to $125,000. The notion that law was reserved for the elite and that the profession was largely white and male was something that I recognized, but I didn't see it as a barrier to becoming a public interest lawyer. It wasn't that I was naive about who controlled our society. I was just hopeful. I entered law school in the in the mid-90s when Latinos were beginning to cement their political power in Los Angeles and in California. We had our first county supervisor. We had more than one Latino in the Los Angeles City Council. We had multiple representatives in state legislatures and Congress. So there was hope. I didn't necessarily correlate elite and white with public interest. For me, law school represented an opportunity to have a seat at the table, to have a seat to advance issues that I cared about for my family and my community. I believe that if I got to the table and offered a new perspective, it would be considered with equal weight and deference. I didn't realize then that the fact that I was not white or male meant that there were certain rules at the table that I would be expected to follow. These rules included, first, participation is conditioned on being satisfied with the status quo. 2, when you arrive at the table, show gratitude by never questioning or disagreeing with those who let you in. And 3, make sure that every chair you pull to the table matches the ones that are already there. I learned these lessons in the following way. First, the notion that I should be happy and satisfied with being at the table began as early as my first meeting with my public interest advisor in law school. When I expressed my intention to return to Los Angeles and use my degree to work to advance interests, particularly of the Latino community, I was immediately pointed to public interest law firms who engaged in impact litigation. I was told that impact litigation firms were the gold standard of public interest law. If the Latino-specific MALDEF didn't work out, well, there were also other organizations like the ACLU. They may be a good fit for an elite law graduate like me. The other option for me would also be to work in a government agency, like the U.S. Attorney's Office, specifically in San Diego, who really could use my Spanish-speaking skills. Those were highly coveted there. Also, as a last resort, if I was really looking at public interest, well, there were a number of legal aid organizations in Los Angeles County that I could apply to. I did apply to some of those public interest organizations, but none of them made me an offer during my first year of law school. I guess UCLA graduates got to them first. I split my first year summer and worked primarily in public interest organizations. But I also dabbled for a few weeks in the housing department of the LA City Attorney's Office. These experiences were wonderful. I learned a great deal, met amazing lawyers, but I discovered that neither public interest or government work was really for me. When I expressed my reservations about my fit for this type of work, when I expressed these reservations to my counselor, she really wasn't sure what to do with me. She said we just keep trying, but really she made me feel like I was just being a little difficult. At the beginning of my second year of law school, when I decided to walk across the hall to the Career Services office to register for the big law firm recruiting season, I did so because I had a lack of direction about what could be counted as public interest. And it wasn't necessarily because I wanted to go work for a large firm. As a first-generation law student, I didn't know that many lawyers, so I didn't know what was out there, what was available. I remember finding it odd that career services offices, or that career services office was consciously separated from the Office of Public Interest Advising. That separation was not just physical. The message was that public interest, defined within elite confines, was not a career, it was a social justice-inspired mission that only a handful of lawyers could be able to or be willing to do, or could follow. Like many of my classmates, even those who started out as public interest focused, I ended up at an elite law firm job for my second year summer. While I wasn't thrilled with the prospect of working at a large firm, really my participation in OCI was really a rejection of the kind of advising that I was receiving at the public interest office. At this point, there were also personal considerations that were weighing on me, primarily my family's financial situation and this pending law school debt that was very real. And back then, it wasn't as real as it is today. It was during my time working at an elite law firm that I learned the second rule. I learned lessons about the second rule. When you're at the table, show gratitude by never questioning or disagreeing with your supporters. My experience at an elite law firm is what really highlighted the male and white default of the profession. I chose this particular law firm. It was based in San Francisco, and I chose it because of its commitment to diversity and pro bono work. It is a theme that was repeated throughout the summer and throughout their glossy brochures and in any possible public opportunity that was available to the law firm. Success at this law firm, which, by the way, prided itself in its diverse hires, but it had 800 lawyers, and in the partner ranks only included 2 Asian Americans, 1 African American, and no Latino partners. There were a handful of LGBT partners and even a few more women partners, but that was the extent of it. It was 800 people, lawyers. Halfway through my first summer, I questioned the commitment to their diversity and the working environment that I was in by asking a partner who had recruited me to the firm for assistance in helping to contextualize comments made by another partner that, in my opinion, revealed great bias. I really was looking for mentorship and figuring out how to handle this. This inquiry was not handled well, and although all those involved really, I believe, had good intentions, it really led to an uncomfortable situation and one that I did not anticipate. Instead of focusing on all the details of that experience and having to relive it, I will say that at the end, the partner who made these comments that I was questioning felt ashamed and angry, and I was labeled a troublemaker. The idea that I was disruptive to the culture of the institution led to me not finding mentorship, not getting good assignments, and not being amongst the first, and being amongst the first associates to be let go of during the 2001 recession that affected the legal profession. Ultimately, this experience helped me understand the expectation that to be successful in a predominantly white and male elite environment, I was expected to accept the status quo and not question it. The difficulty in leaving the law firm was not that I would not be getting a 6-figure salary, but it was in finding my own identity in the law, because I had relied on others to create it for me at this point. Although I knew I did not want to be in an elite law firm, the truth is that much of my professional identity had already been surrendered to the notion that I needed to conform to a certain standard to be a member of this prestigious club. The day that I was sworn into the bar, I remember it very, very well because I remember feeling relieved that I had finally pass this final jump, this regulatory hurdle to becoming an attorney. But what I remember the most is a feeling of grief and resignation. The panel of judges and attorneys that were part of the swearing-in ceremony were all white and were all male. I was fortunate enough in my transition out of elite law firms, out of this elite law firm, to negotiate a good severance package. Since I was already referred to as a troublemaker, there was no need for me to leave quietly. This particular cushion basically provided me with the luxury of a few months to really explore my options. After interviewing at a few places, rejecting a couple of offers, and being rejected at others, I took a chance on myself. I started my own practice, and I did this with the understanding of serving a community that I went to law school to represent. Although public interest advisors had never pointed me in this direction, becoming a lawyer based in a community that I understood and did not feel threatened by was the best reflection of who I wanted to be as a lawyer. Individuals who came from similar socioeconomic backgrounds as mine saw my decision as an opportunity to build a community practice as a manifestation of my public service goals. However, many in the local public interest community did not. And it was this experience that taught me the third rule. To make sure that every chair you pull to the table where you're part of that conversation matches the ones that already exist. In other words, don't dare to change the paradigm. The discussion of this rule is a bit more complex than the previous ones, particularly because it really delves into whiteness and public interest, and that's a model that few folks really want to discuss. My main perception of whiteness as property in the public interest world is a common belief amongst many public interest lawyers that if a client pays for a service, it does not advance the public interest. I disagree with that. My experience as a community-based practitioner working in an underserved community helped me identify myself in the law because it helped me understand that poor people don't always stay poor, that folks who are not classified as poor may really be near poor or only a few paychecks away from financial ruin. And the people that I helped in my own experiences as a community lawyer also made me face financial ups and downs as a lawyer in the startup phase of my own practice. And it is this experience in terms of figuring out how to characterize the work I was doing that ultimately led me to academia. In order to recharacterize the paradigm of what is or can be public interest, I needed to use the white and male elite tools of advocacy that you can really only find in academia. In this environment, the effectiveness of advocacy is often measured by how much whiteness an advocate is able and willing to embrace. Advocacy must exist within the confines established by white dominant culture, which has primarily described public interest as impact litigation, government work, and if you really need to go there, direct legal services. All of this requires that you do not charge clients, and it assumes that clients will always be poor. But going into an academic environment allowed me to use things like writing and speaking and conferences such as this to be able to advance conversations about what it means to be an attorney of color advocating for interest of communities of color. So now that I have the credentials that reflect the buy-in to white privilege, and I know that those credentials, if used in the proper context, can generate greater credibility and deference to my positions, the ability to shift the primary discourse in legal education, legal services programs, or within the framework of what the bar accepts as public interest, requires that I continue to disguise myself in white speak through writing and similar advocacy tools. These tools are really helpful in getting a seat to the table. and they're helpful in advocating for a new paradigm in legal services delivery that address the needs of those who fluctuate between poor and near poor. I've had to confront and accept the pervasiveness of whiteness in our legal system in a variety of ways, as many of you have. Working in clinical legal education and public interest circles has required that I accept that effectuating any change at any degree ultimately requires that I engage in some co-option of my true self. I have now become comfortable with that coming in and out of different worlds. The world of who I am and what I know, and the world of who folks want me to be to participate in the conversation. I stopped resenting that, and I now accept it. And in fact, I actually see it as a necessary step in the process of bringing a very different seat to the table. I share this perspective with you as a personal narrative because I really want to engage in a discussion about how the changing demographics in our country requires a conversation not about adding more seats to the table, but about reconstructing the conversation to allow for different seats and perhaps a whole new table. Thank you.
Okay, I'm going to speak from the table. And I want to thank Mira and Luz for inviting me to be part of this panel. I accepted because they asked me in part, but also because I think that whiteness as property is an interesting way, an interesting lens to look at the legal profession, as we've already seen. Now I also understand that they invited me because I represent property. And they thought that the panel probably had a better chance of getting selected if they could insert me in the group.
We also love you.
So I'm going to really do three things. I'm going to start with this After the JD project, which is following 5,000 lawyers from the class of 2000, but I'm only going to talk about it kind of indirectly. I'm going to talk about one way that we're kind of interpreting the data for the third wave. It's 15 years project, and we have quantitative data and we have qualitative data. And I'm just going to race through a few things that relate to how you can organize this data. You can organize it around a very simple proposition, that the top of the legal profession, what we can call as white, it represents a number of different characteristics. It's graduation from an elite law school, it's partnership in a corporate law firm, maybe secondarily an elite public interest law spot. It's having a full-time wife at home, being white, being male, and traditionally being Protestant. That is a very nice way to understand what is hierarchy, and indeed the things that allow you to advance in the legal profession are some combination of those components. And they're not explicit now, they're neutral and almost invisible, but I thought it was interesting in this morning's panel when there was talk about Defense of Marriage Act and the Supreme Court and who the plaintiffs are. It's taken for granted that the lawyers should be white, male, corporate lawyers, who are at the top of the profession, handling the case. We don't look carefully at how those categories reproduce themselves. So I think what's also good in the article is it gives you the idea that, if you see it as kind of reified property, then you don't really see how it operates because it operates almost invisibly. The law firm reproduces itself, the hierarchy reproduces itself, but you see it from different mechanisms. So you have the requirement of billable hours and working weekends, which really necessitates, a spouse at home ultimately in order to succeed, and you can see that very much in the careers and in the interviews. You have the assumption of who ought to get the best mentors, who gets to be passed on the best clients, because in order to make partnership, you need these things. And the way it works, and I think Luz demonstrated it very nicely, there's a way that if you're white male, you don't have to prove that you might be a rainmaker and that you would be comfortable with those clients. If you are not, you almost have to prove the negative before you can prove the positive. You have to prove that you're naturally disqualified. So, of course, it's all implicit and it's not talked about. but you see it very much in operation as it proceeds. And we see it, sometimes there is the explicit. In the wake of 9/11, we interviewed some Islamic lawyers who basically said they were just made so uncomfortable with the questions that they got in the hall every day that they just had to leave. There was no chance. Now, when you see how this plays out in the data, it's pretty clear. And I have one table that I'm going to talk about but not put up. And that is if you just look at attrition in large law schools, by race. Gender is the same, but I'll just give you the race right now. Okay, blacks in our sample started at 20% of firms of over 100. That is 20% of African Americans were in firms of more than 100. Went down to 10% at 7 years, and then went down to 8% after the JD3, which is 13 years into the practice. So cuts down by a third essentially over time. Hispanic starts with 20, then goes to 11, then stays at 11, which you might think sort of shows a kind of a commitment to Hispanic diversity. But I think we would really like to know how many Mexican Americans are in that Hispanic category before we celebrate that success. Asian is a particularly interesting category here because Asians were deemed always kind of the model minority and success in large law firms. And you see it starts out with 29%, goes down to 18%, and then what is quite striking is between the second time and the third time, which is really partnership time, there's attrition by another half, so down to 9.4%. So there's a kind of a massacre that takes place between waves 2 and waves 3, which really suggests, and there's a book I think Mia introduced me to called Partner Track, which kind of illustrates this, which is, it is that what seems to be great in a worker, umpteenth year associate is not deemed to be the partner. And probably if you act like a partner, you'll be deemed to be acting out of your role. So it's a catch-22, and you see that attrition take place quite clearly. And all this exists despite what is a huge and deeply felt commitment to affirmative action in the large law firms, which you see in the initial hiring. But you don't see them make up for the structural whiteness of the firms that plays out over time. And that makes it easy for the neutrality of this whiteness to say that failure to make partner is lack of talent, et cetera, just doesn't have what it takes, and the like. And there's we had an interesting interview with a DC lawyer who said that, hey, he said, our firm, we have had 5 black partners, we win awards for diversity almost every year. And he says, in another 5 years, we'll have 5 different black partners and win another award. So the problem, at this level is reproduction of class and race, and the metaphor of whiteness as property is a potentially powerful disruptor of complacency, and in a way it makes the case for affirmative action obviously even stronger. So now I want to talk just a little bit about other research that talks about this issue in a different way, and this is more global type research. So my collaborator and I did some years ago a project on international commercial arbitration where we asked who gets to be a big international commercial arbitrator. And one of the things we found, not surprisingly, is exactly the sort of proving the opposite problem that you have when you talk about whiteness in a large law firm. And the proving the opposite is if you're from Africa or from any developing nation, essentially you can't be an international commercial arbitrator unless you can prove that you're neutral and not too sympathetic to developing countries' concerns. So there will tend to be one maybe, and usually you could say they've bleached themselves by becoming justices of the World Court or by teaching abroad, but there are ways that they prove that they can be trusted. Whereas if you're Swiss or you're US or you're French or you're British, you are by definition neutral and able to, make sure, of course, it's about protecting property rights in international commercial arbitration, but there's a way that plays into this. And so that, to me, is really just the same and a reproduction of what we just saw. But what I want to push a little bit more on is that what that means is in order to get that seat at the table in international commercial arbitration, it's not just that you have to prove that you are not too controversial, that you can be trusted. It also means you aren't controversial and you can be trusted. It means that you are buying into, Luz talked very much about this, you are buying into, reproducing, legitimating exactly the rules of the game of international commercial arbitration, which are designed, above all, to enforce property rights of big companies, often against states, as we see in a lot of the international investment, which is something that's being talked about a lot these days. So I wonder, just as a thought, whether that is something that needs to be more elaborated in a discussion of whiteness as property in the U.S. as well. And then to add one more kind of bit of research that might relate to this in a kind of indirect way, it's empire. You know, if you go back to the famous Macaulay quote about the British Empire, the idea of educating, mostly in law, Indian elites, bringing them to the Inns of Court, giving them a law degree, sending them back to help the British rule, was to create a class of Indians, British in intellect, taste, and temperament, but Indian in color. That was the idea, is that you create a group that will then go back and in a way represent the empire. Now it also means that because they've been, you know, to use the metaphor of the day, they've been whitened in a sense by going abroad. When they come back, because they represent the power and the elite of the British Empire, they come from status and it reinforces their local status. So those were indeed the leaders of independence. But when they led independence, it was an independence, you know, and I'm not criticizing this, is the way it played out, an independence that meant that India was a natural ally of the British, rule of law, constitutions, all of that. The same was exactly true in the Philippines with the U.S. Empire. You know, we took the Philippine elite, they would come back and get degrees at Harvard and Yale, but of course they were from the Philippine oligarchy, and they would go back and rule in the name of the rule of law, but reinforce the credibility of the U.S. empire, just as the British reinforced the credibility of their empire, through this, what you could call affirmative action of legal education, pulling people in, you know, giving them degrees and sending them back. So there's a way that opening up the process, especially to law, you know, which is, you know, the slow process of change. You know, it's moving without the violence. And so the big conclusion, and I want to make and give us at least 5 minutes for discussion, is that this hierarchy of reproducing an elite, legitimating the center and the rules of the game at the center, maybe is something that, you know, you could add as another dimension that I think it might be addressed in some of the colonial ones, but is another dimension that relates to this kind of whiteness as property, because you see exactly how it also is a way to, you know, by accepting it, by bringing people in from the periphery to the center, you also strengthen the center, even though you also provide some spaces at the periphery. Okay, I'll stop.
Okay, so there's lots of really key threads throughout their comments. One of the key threads, I believe, is that the assumption of whiteness in certain spaces and how that works to really reproduce the very structure that we're trying to contest. How it works to exclude people when it's taken for granted that certain bodies will occupy these spaces. The other thread that comes through there is the question of and I think Luz asked this, and also Brian and Mira, can the master's tools dismantle the house? And in particular, they deal with this of being at the table or being included doesn't necessarily signify change. And I think Devin Carbado and Me Too Galati's piece in the Washington and Lee Law Review on Race to the Top helps to explain this. It may mean that the few people, as Brian was saying, who are included actually work to protect the structure that is oppressing and excluding people. And And Luz, in particular, also talked about how if one is included in the structure, right, they're in part included, as Brian said, because they're not controversial, they may not try to invoke too much change, they can be trusted, that they can be punished, right? So in her own experience, because she was a troublemaker, she was punished. She was denied benefits such as mentorship and good assignments, and was ultimately someone who was forced out for that reason. And so I have a couple of questions those are important threads if people have questions about those, but I have a couple of questions for everyone. So my question with Mira is are there ways in which the concept, the idea of what the article, Whiteness is Property, offers us some insights on what I would say is the link between the increase of minority deans during this particular time, this particular moment. So now there's certainly a downturn in law schools, and yet I feel like every time I turn around, I see a person of color has become a dean at one of these law schools. And does that shed any light on that kind of phenomenon? For Luz, I'm curious to know what your thoughts are on whether you think there's a link between the cost of law schools now and or in what ways does the cost of law school help to reinforce this notion of the public interest learning as something for the white elite, those connections there. And then my question for Brian is, what's the solution to this problem of dismantling the master's house? Are we forever doomed, or is there a way to get people at the table who are not trustworthy, or is it simply destroying the table and starting over?
Go in reverse. Well, first of all, it's an easy question. I can solve it in just a couple of seconds. To me, this is inevitable. This is the process. Power does reproduce itself, and to pretend that it doesn't, and there are different ways it reproduces itself, and one of them is through legitimating itself, opening itself up, providing. Even though I really spoke up strongly that it legitimates the rules of international commercial arbitration, it also changes just a little by having different voices in there. So it's a moderate change recipe, and unless there are external crises that change the values of the different capitals and and ideas, but mostly I think it's just, for me, I think it's really important for us to make explicit these processes that reproduce. As a sociologist of law, I'm bound to say that. But I think that allows you then to see the processes and not fall for things like assuming that the, Olsen boys, by definition, must be the best people to represent in the Supreme Court because they're at the top of the hierarchy, and therefore we bow to them.
I'll try to address it. I mean, I'm not sure. We could probably have a whole other panel discussion about your question. But I mean, I do see that the cost of law school does reinforce the public interest elite, and specifically in a couple of ways. One is that traditionally, I mean, I remember thinking in my second year when I had to make a decision, I actually did get an offer from a public interest organization, and I got it just a few days after I had accepted my law firm offer. And I remember, I said, well, I could always go back and renege and take this because it's, more in line of what I want to do, although it wasn't all that I wanted to do. And I remember thinking, gosh, that would be the right decision if I was wealthy enough to do it. I wish I was in a financially stable situation in my family life that I could do public interest. And for me, it brought in really these other considerations of who I was and who my family was on the kind of social economic ladder, and so that really motivated that decision. But I remember the folks thinking about the folks who went into public interest, because you didn't have as many postgraduate fellowships that paid you, at that time. Most of the folks that went into it either had no financial obligations to any family member, right? So whether it's a parent or a child or anybody else, or had a spouse that was going to subsidize their public interest salary. those are the majority of the people that went into it. And so I do think that you get a kind of a certain type of person that goes into public interest law directly into law school, and specifically because it's such a competitive field that it's only 1% of all lawyers. And so the folks that have access to these fellowships are folks from elite law schools. And so 70% of law school graduates that really want to do public interest don't have a shot at these fellowships. So I think in some ways that it happens. I mean, I think the other part of the question is really, how are law schools choosing to allocate their scholarship money in terms of, folks that come in, particularly if they're coming in from strong, more solid socioeconomic status, might have more access to LSAT courses and other prep courses, or might have come from a family of lawyers. And so if your law school, because you have a high LSAT and high, good grades, is going to pay you on the back of somebody who didn't have those privileges, pay you to come to law school, then, folks that might not have had that, those resources to prepare to law school might be straddled with more debt than the others. And we see this, I think, really in terms of the different law schools that are currently suffering in this economic time. So, I mean, there are a lot of these things that happen. I do think that it's a little bit dangerous. I mean, we spend a lot of money on postgraduate fellowships at institutions, and they're really wonderful. I think they're more wonderful when they exceed, 6 months or 1 year, because folks need to develop careers in these areas for longer than that. And so for me, that's why I really advocated the development of attorney incubators and modest means programs, because they provide tools for students to, for graduates to figure out how to generate their own money past this 6 month or 1 year honeymoon that fellowships provide.
Can I add one little piece of data? We know from this after the JD project that Rebecca Sandiford did a study of public interest lawyers and found that their spouses on the average earned more than other spouses.
One thing I'll add about the public interest lawyering as well, it's no secret to anyone who knows me that the 3 years that I spent at Michigan in law school were not the best 3 years of my life, but I will always be grateful that they instituted at exactly the time that I graduated a loan forgiveness program. There was a graduated program, so if you made any money at all, virtually, you would start paying back some of your loans. Luckily, I guess, I made almost no money at all, and so I qualified. And so there are, I think, structural ways that institutions can support public interest. Of course, they have to be willing to do it. And like I said, I graduated in 2000, so I'm part of Bryant's study. But that was the first year that Michigan Law School had instituted that sort of program. I also, before I answer Angela's question, feel like I have to take one moment because I think I have an opportunity here that may never present itself again. We are in the presence of probably the largest collection of my individual mentors that have ever existed in one place. So now you're feeling embarrassed because you think I might single you out. I will. I'm going to start with Devin Carbato because he was on my dissertation committee when I was a graduate student here over a decade ago. So Devin Carbato, both Angela and Bryant, Laura Gomez, and Jerry Kong have all been mentors for me. And you know from the research that I presented how important that is. And so many of the participants in the study said it, and I will repeat, it's really impossible to move ahead. Jerry actually is the one who convinced me that I wanted to be a law professor instead of a sociologist. I don't know if you remember that, but I still feel like I'm a sociologist, but he was the one that said, here are the many reasons why you should consider this as an alternative, and like many of the people in my study, I really had not considered it as an option, in spite of already being a lawyer. Okay, so the question itself about the increasing leadership opportunities for people of color and how to connect that to whiteness as property. Well, I would suspect that many of those, the people that are stepping into those leadership positions now have sort of the elite credentials that make them seem more palatable, right, to be leaders in those positions. But they still, as I hope you could see from the data that I presented, are white spaces, right? So in a couple of parallels to Obama, I don't know if any of you have friends who sort of challenge whether or not there is ongoing racial discrimination, and they point to our black president as a way of showing, perhaps we've moved beyond the challenges of race in the U.S. And I would argue that the same thing is true at law schools, right? So even if they are headed by a person of color or a woman, that person is still, surrounded by a space that is probably not their own. I mean, I was struck in part with Luz's comments. I wrote this down. She said something about finding a non-threatening, comfortable space. And that was in Compton. For her, that was a non-threatening, comfortable space as compared to the elite law firm she had worked at, right? So I would suspect that, the women of color deans who participated in my sample, maybe not directly, but using those words, but their experiences indicate that as well, that there are still challenging situations in spite of their being in those positions. The second parallel to Obama is what makes me nervous about the increasing opportunities for women of color. I certainly want to encourage more people to consider that path, and I know there are many others doing this more directly and with greater influence, I'm sure. But I am nervous about the likelihood of success. We're not creating conditions of success, I think, and I suspect that's part of why the opportunities are available and maybe why the opportunities are flowing in the direction so that women of color can step into those positions themselves. Not optimistic words, I'm afraid.
Laura.
Thank you all for a thought-provoking panel. I wanted to make a couple of comments and ask a question. So just to follow up here on where you just ended on the dean question, I was wondering if it would be a useful frame to think about how, as professions have lost power, there tends to be an increase in women going into them, right? So sociology, law, and so I sort of feel, even as I have been involved in this process very directly myself, I feel like law schools are becoming law school deanships are much less desirable today than they were 10 years ago. So doing that kind of service work in institutions is much less desirable, right? So it's certainly not remunerative in the same ways, and with law schools changing. So I had the same question that you had, Angela, about affirmative action in terms of thinking about your presentations, especially yours, Brian, thinking about it very much, the data, after the JD data, feeds into the critique of affirmative action from the left, right? Which is it's just a way to reproduce elitism. And, so I think that it would be interesting to think more about that kind of two-edged sword there, right? Even as that's a place where affirmative action can go on. These firms say they want it, they're talking about it, they're trying to do diversity, quote unquote, but at the same time, it feeds into this critique. The question that I have, and I think it's really something that all of you might want to address, certainly need to address, but you might want to think about, and it goes back to the invitation, Mira, that you raised about methodology and talking about that. If we sort of think about, Luz, your presentation is you're giving us a life history narrative of a story about a law student and a legal professional, right? And the texture of that was really powerful, right? And the depth of that. Your study, after the JD part of it, Brian, is a huge study. It has a quantitative and a qualitative component. I'd like to hear more about the qualitative component because I don't know if it taps enough into the life history part of it, and I wonder what the parameters of that are. But I think it's very admirable that you guys adopted a mixed methods frame in the beginning. And then Mira, I think your study is just qualitative, right?
It's both. I mean, I do collect survey data, but I can't run fancy regressions, so I only have 97 people. So
the survey data, and then again, I want to hear more about your qualitative interviews and whether or not and for the critique of qualitative data, right? Of course, is that it's very subjective, right? Depends on what questions you ask and the report that you have, and maybe they're saying what that they think you want them to hear, etc. And so, at the same time, my own sense is that the quantitative data, like the big N data that we're getting with the after the JD study, which is very powerful, is really going to be not helpful without the deeper qualitative data. So, for example, the Asian American numbers, right, the shocking numbers that as you mentioned, right, which go down to less than 10% at that 13-year point. There is a really powerful story there, and it fits with some other stories that we're seeing in law school admissions even, and in different professions, and I'm not sure how, as social scientists, we can best tap into that without rethinking how we think about methodology, in the more rigid ways that we do.
I can answer a little bit, which is, I actually want to write a paper out of the qualitative stuff, which in a sense uses the qualitative stories to show each of the pieces of what we call kind of forms of capital that get you ahead and behind. And I think one of the striking one has been this time issue, who controls time, because that's the big gender issue that you see. And we really see it in these interviews. And, we have some great, from the researcher perspective, tragic stories of what's happened in large law firms with some of the Asians, particularly Asian women. And so that's something that I think we can tell that story, absolutely. And yeah, I totally agree. I mean, I much prefer qualitative data just because I think you can tease out the nuances from that. And then what we want to do is take a mix of the qualitative and try to then find all the variables that might be the contributors, and then go back to the quantitative data and see if you can actually find that there are correlations, once you've actually come up with a model of what gets you ahead and what doesn't.
I'll just say that probably the biggest pushback I've gotten from the study that I presented today is with regard to the methodology. I gave a talk 2 weeks ago where someone didn't exactly, but sort of asked me if I could come up with p-values to reflect the qualitative data, like which of them are greater or less. And I try not to get too frustrated and ignore it altogether, because I recognize the value in reaching an audience that might begin skeptically by looking at the data and showing them why it is valid and reliable. And so the first article I published from this project was an article that just lays out the literature and the methodology. I was hoping that I could do that and then just reference in every other article that's coming out, reference back to that first one, but I'm finding that I can't really do that. So anytime, when I give a talk like this, but the paper is included, I have sort of the abbreviated methods section strongly footnoting the other article to look at, and I think it's probably not enough. So I think part of it is just including the focus on methodology more, so that the people who aren't interested or who believe you anyway can skip it, and the people who would be skeptical if they didn't believe it would have an opportunity to look more carefully at that as well.
Any more questions? Yes, right here.
I'm wondering if you can discuss a little bit, Mira, about the different burdens that you seem to imply that women of color professors have that maybe white women didn't, that kind of led to their reasoning as to why pursuing administrative teachers was not in the cards for that.
So some of it deals with family. There are, I think, greater family obligations for women of color than for other groups. Some are single parents, but it's also a greater commitment, I think, to extended family and community. So one of the women in my sample, who is an associate dean, actually, was recounting, before she had started even as a law professor, she was married at the time, currently not married, but married at the time and working at a big law firm. Her husband was working at a law firm as well. And she said people she knew sort of suspected that they were financially illiterate or irresponsible, without realizing that in addition to the two of them paying for their nuclear family with their 2 law firm incomes, which for many people is, obviously sufficient, that they were also paying completely for her mother, who lived separately, her father, who lived separately, and her husband's parents, who lived together. So that, I think, is a very real situation for a lot of people. Now, if it were just financial, right, you often do get a significant bump in salary if you take on those positions, and so you would then have more financially to spread around to the extended family and community, but it comes at great expense in terms of your time as well. A lot of the women of color in the sample also are actively engaged in the community. Most of them didn't talk about it as volunteer work or charity work. They just talked about it sort of as the thing they felt responsible for doing. So whether they had a church family or whether they were involved in the neighborhood, many of them had a lot of things going on in addition to law school. So, theoretically, I think of it as kind of not having their professional or personal identity as wrapped up in their current position as a law professor as maybe some of their colleagues do.
I have a question. So this morning I learned that the Supreme Court granted cert to a fair housing disparate impact case out of Texas. And I'm a fair housing lawyer for a nonprofit here in Los Angeles, and also graduated from UCLA and CRS program alum. And one of my initial reactions, and it's actually still a lingering reaction, which is why I'm asking this question / comment, was that I was very curious about who filed the case. And I went to this nonprofit's website, and I went to the About Us to see who the staff was, and there was no information. So I don't know if that information was there previously, and then when they learned that they granted cert, they just took that information off. But I'm curious about and wonder whether, and this is still a question and a comment to the entire panel, on the absence of meaningful diversity in public interest organizations and how that impacts an organization's ability to advance the interests of the communities they serve, questions of accountability, and whether we need to actually start thinking about having state bars impose ethical obligations on these organizations to the communities they serve. One of the biggest challenges that I sort of face as a public interest lawyer comes from other public interest lawyers who are well-intentioned and they do impact litigation and they think they're doing great work, but there's no meaningful diversity at the decision-making level. So when they think about strategies, they're not really thinking about, they may think or believe that they're thinking about the best interests of the communities they serve, when in fact they're hurting these communities. And so I think about this Texas case, and if I were a resident in Texas, as someone who would be impacted by this case or the outcome of this case, whether I would be able to actually lodge an ethical complaint against this organization for filing a case that they know or should know would potentially make its way to the Supreme Court and then lose. So it's more like a common question to the panel on the impact that not having enough people of color at these public interest organizations, and even law firms that do pro bono work, how that impacts an organization's ability to be accountable to communities.
I have a paper I haven't published, which is basically the links between corporate law and elite public interest law, which tries to deal with some of those kinds of issues. But yeah, it's a fascinating one. And one of the things you saw, with the rise of the left in the 60s and 70s and the rise of the right in the 80s and 90s is the first generation of sort of social change lawyers are outside of the elite mainstream. Then it gradually gets gobbled up by the elite. And it ends up that, they have the right and the left, in a way, as such as it is that remains, have more in common with each other than they do with the movements that they initially represent.
Well, I mean, it's an ongoing conversation. It's an ongoing conflict, and it's experienced in all in all types of ways. I think part of it's also that it goes back to the lack of opportunities for a diverse pool of lawyers to work in these organizations. So it's not just diversity in terms of color, but it's a diversity in terms of socioeconomic status, law school that folks attend, right? Because I think all those, what happens is that you might have, a brown, a black, a yellow, and a purple person at these organizations, but they all went to Yale or Harvard or Stanford or UCLA, right? So if we're picking from 10 schools the leaders who are determining what communities need and what needs to go to the Supreme Court, then we're going to get a very kind of small, view of what these communities need and require. So I think, true diversity really requires looking at who might have some connections to community, and that's not always folks that come from only elite schools.
So I'll just say briefly that Derek Bell, wrote this seminal article, Serving Two Masters, and many people think of it as a conflict. That's sort of the point, that you have these two masters as, a public interest lawyer, let's say, where you want to do what the cause is, but you also need to serve the community. And I would venture to say, I hadn't thought of it this way, but in response to your question, that might be a good problem, right? And I think you might agree that if you feel the conflict between serving the cause and serving the community, at least you have that connection to the community. And then you might try to balance your personal or the larger mission's ideals against what might be best for the community. And I agree that it's, my first job out of law school was at one of the elite public interest organizations that Luz was mentioning earlier. And there certainly is that disconnect, where the organization puts together the case and then looks for the plaintiffs, which doesn't mean that it's not in the greater public interest, right? But I had, as Angela mentioned, come from Grutter litigation, where we were organizing and writing briefs kind of at the same time. So I don't know if there's a solution necessarily, except to find a larger structural way for more people of color to move into those organizations and find a way to assume leadership positions there. But I certainly recognize the problem.
I would even say that Ted Shaw says that the harm that you point out even extends even further, that it's not even just in who brings this case, even when it may not be in the best interest of the community, but who gets to speak also once it's brought. So in the Grutter case, the interveners, your attorneys didn't get to speak, didn't get to argue during that, right? And so you have entire voices, entire arguments that really don't get put before the court in a really prominent way, and so it'll actually grow as this case moves on. And I'm not sure I wish that an ethical complaint would be possible, but I'm not sure that would do anything, because it would be the same people, right, in the structure deciding that it's not an ethical problem because the attorneys are trying to act in the best interest of the community, and who are they going to view as more credible, and so.
And it's at least possible that those are not elites; those are complete outsiders. If they talk to elites, would actually know better than to file the case. You need to check it out.
I have a follow-up question concerning the additional obligations that you found out, particularly women of color found. So you mentioned the outside obligations. I wanted to see, I guess for all the panelists, whether there are obligations within the profession. So are they now expected to be involved in, BALSA or diversity committees and the like? And so whether they come into the profession, I guess in some ways burdened by that, because I would imagine, for example, for a white male professor, if there are any expectations of him, it's related to his scholarship or whatever his interests are. Whereas for maybe a black woman, it might be expectations in terms of her serving interests that are related to black women or blacks or whatever the case may be.
Let's get two more questions out, since we're all getting close to. I'm right next to you. You right here.
So I started law school 20 years ago, and much of what you guys are saying, as you've now studied statistically, just rings so true to my entire experience, all the way back from law school, toying around with different career paths, lack of support for really pursuing what I wanted to do and what I had gone to law school to do. I've since spent the rest of my career mostly, I clerked for an appellate judge, and then I've been in private practice at large law firms. And when I hear what you guys are talking about, and you think about all the structural barriers and the big changes that need to happen in our society for women to truly be able to, be equal and people of color in institutions like these big law firms. But what I'm wondering is, has anything changed in law schools in the last 20 years to really equip people better to deal with what they're going to experience when they get there? Because you can hear these stories and the statistics, but there's a great emotional cost to each individual's experience of living in that culture and maybe not surviving and having to move on and losing a job, et cetera. So I'm just curious if things have changed or what we're doing differently.
One
I
more
can do-
question. Can we get,
no, go ahead.
We'll get Lisa's question and then people can respond.
Thanks. So everyone in this room who knows me knows that I'm going to invite you all to say more about class. Bryant mentioned it in his comments. Luz mentioned it in the response to the question, and I appreciate that very much. But there, you still haven't touched on it, and I'd love it if others touched on it in more detail, and in particular, thinking about where poor and working class whites are in the whiteness as property framework. So Mira, you mentioned, for example, Angela Harris et al. And they're presumed incompetent, but you didn't mention that the subtitle of the book mentions class as well as race. And so how could we and should we, complicate the intersectionality picture that you're exploring by also looking at class? And again, inviting the others to comment more on class as they might see fit.
So I'll just say quickly that since the focus of the study is on women of color, and that's the intersectionality piece that I'm covering directly, the response that I gave earlier to this couple who was in this potentially very high socioeconomic class position ended up then not actively fitting necessarily into what we would think of as someone who had two very substantial incomes. So part of it is income and wealth, right? But that even the two people I was talking about there, the husband and wife, involved, and only the woman was involved in the study, but that was one that I think addresses the issues of class, even though it's not about whites. So it's hard for me to look back and see what patterns might come out from the two small samples of white men and white women, and looking specifically at class issues that affected them. I will say there are some obvious patterns, right? So these are things that are not new, but to the extent that they are virtually required to have these elite credentials, most of them, the whites as well as the people of color, but especially the whites, are from wealthier backgrounds than the others. It's certainly easier. This is true for the white men, I think much more so, but most of them, as Bryant mentioned as well, have women. Most of them have wives, but even if it's not a wife, there's someone who is either full-time at home or else not the primary breadwinner in the family, and so able to sort of pick up a lot of the household or childcare slack that the person who's either in a law firm or a law professor is not able to commit to at the same degrees. And then I'll just say in response to the other question, thank you so much for that question, that comment. It's certainly true that people of color, women of color, and white women are expected to do a lot of the heavy lifting, both with regard to service opportunities within the law school and within the larger university community. So, you might have 2 committees or 4 committees within the law school, but for most people who are at law schools connected to a larger research or otherwise institution, they're also on the university's diversity committee, and 3 other committees that are university-wide. So the service aspect is certainly something that I think creates more work, and therefore you have less openings available for something like a dean position. There's also the service aspect with regard to students, and there is literature showing that faculty of color and women faculty tend to both want to do more with students, but also are seen as more accessible and approachable by students, and that's for students as a whole, white students as well as students of color. And so all students tend to gravitate towards, I'll say, non-traditional law teachers, as opposed to the white men, which, I think some of the white men in the sample were kind of disappointed about, but which obviously then frees up more of their time to focus on usually scholarship-related activities, but which certainly, as you suggest in your question, could make them feel like they would have more time to spend on administrative positions as well.
Okay. Well, I think class plays a huge role in the kind of the structure of public interest, and so there's I think there are a lot of similarities in that way, and I when you asked that question, I immediately thought about the work of Gerald Torres and Lonnie Guinier in this area in terms of collaborations and partnerships. But I also thought about Ian Haney Lopez's work, recent work, right, in terms of politics gets in the way, and then there's a co-option of where similar interests might align themselves to really change a paradigm. And so that's that's the reality of what we're working with in the profession. But I mean, in terms of numbers, it's the profession is still majority white and male, but throughout the kind of how it's stratified, and I'm not, you can answer this better, Brian, because it's just your research, but you have kind of great numbers of folks who are doing community practice, although they might not think about community practice in the same way, that are not people of color. So I think there are a lot of similar issues, but there are politics and preferences that get in the way of coalitions to look at similarities.
Just a couple of points. One is on class. As I think Luz said this too, it's embedded in the hierarchy of law schools, because the lower the rank of the law school, the more likely there are working class kids in the school. So it reproduces itself very definitely that way, and then it's completely invisible. Interestingly, class seems to be playing out that in the large law firms, because that's not a desirable job to stay through and get partner now, some of the less elite driven working class kids are staying in, while those from the elite credentials go in-house, where they've got a little better lifestyle, also good money. So the elite track may be changing, but they'll end up back in corporate law firms at some point with those corner offices, you can bet, although we don't have it yet. On Laura's question, in a way, about is it just co-option? Should we eliminate the affirmative action, sort of the left critique? I mean, when I say that those 5 black partners and there's going to be 5 more black partners, they probably didn't come from disadvantage, but there's still problems of just plain race, and ethnicity in the large law firms as well. Whether law schools changed, a plug for the Irvine first-year legal profession class, where we bring in lawyers and have them really talk about their experiences. The students are required to ask questions of each practitioner. So we had a solo law firm one yesterday, and they really get to see who are solos, where do they come from, how do they make their days, how does that relate to their lifestyle, and they get a very hard look at what large law firms are like in-house and the whole variety of settings. So I think students really need to know more about the profession. Of course, I've been saying that for 1,000 years also.
I want to just point out, I think one of the important contributions, I think, from Whiteness Property is sort of, I think, one of the questions that Cheryl Harris addresses is sort of why you don't see more of a coalition between working class and poor whites and, for example, racial minorities, and that's about the psychic value of whiteness. And I think there are a lot of ways in which you see that operating in the legal profession. So one example, even just in the law school, when affirmative action debates have come up, and in particular in my school, right, there's this, we have hundreds of students from Iowa who even take the LSAT, and half of the class spots are essentially reserved for Iowans. And so when you're looking at the bottom of the scores, there are in-state white students generally. They're not students of color, and people presume that, and that kind of animus comes out. And you'll have white students who'll say, gosh, somebody said this, and I know that I'm really that person, right? But I didn't feel like I come out. So whatever value they had, they were willing, they were going to, rather than speak up and say something that would help to defend the system that they supported, they wanted to cling on to their belonging in that sense. And I think that I see that play out too in terms of coalitions among faculty members, and it's controversial to say, but it's one of the things that I wish would change, right, in terms of how we form our coalitions or not. Is that psychic value of whiteness more important than forming a coalition with people who are on your side? No.
Schematically, there are kind of three kind of clusters of lawyers that you talked about in different ways. There's the kind of public interest, there's the academic, and then there's the kind of big firm stuff, obviously. groups who are actually trying to carve out another space in that. But all of these are domains that are white dominated and hostile in various ways. But there's a particular narrative about law school, maybe at the beginning of the career, that seems a little bit asymmetrical. And I just want to ask you if you have an intuition about it, which is the story in which the student of color who doesn't feel like there's a path into the legal academy or isn't invited in or into public interest law, then ends up going the big firm route. But like the big firm route isn't exactly one that seems inviting either. And so, but I see that dynamic, right, in terms of my relationships with students. You see that in law school or in that immediate post-career. There's people who feel pushed away from either of those angles end up going, at least initially, into firms often. But like, there's a puzzle there, which is given that those are also institutions that don't seem full of role models. And like, why is there a differential path there? That seems like an interesting question about the ways in which there's an asymmetry among these three different kinds of elite spaces. I don't know if you have any thoughts about that.
I can add one thing which the students pick up is when we have a public interest lawyer panel and they're bragging about what a great public interest organization they have, they say, we've hired people from O'Melveny, and the students understand that the hierarchies are there and that they need that O'Melveny on their resume if they can get it.
There's also...
Go
go ahead.
You go.
I mean, my initial reaction without like polishing it, which is I'm really good at doing, is, if I'm going to be mistreated anywhere, I might as well go where I'm going to get a big paycheck.
It's also sort of the expectation, right? When you're in, especially at an elite law school, that you'll go to a big firm. There is no one ever said to me in law school, you'll probably become a legal academic. Although someone who is a legal academic, who was my TA in college, found me after I was a legal academic and told me over email, I would have predicted this 25 years ago from the work you did in the class. And I thought, I wish you would have told me that 25 years ago. But, it's sort of the expectation. I think it's the expected route.
One last comment, Devin. Oh.
Personally for me, I feel like as a minority, you're drawn to what would be, you're trying to prove that, hey, I'm good enough for this. So for me, I came to UCLA pursuing political science, and I ended up doing both African American studies and political science. But when I would say to people that, hey, I'm studying African American studies, they give you the feeling like, what are you going to do with that? Or something like that. So if I know if I say I'm pursuing critical race studies, it's kind of, oh yeah, you're one of those. Like, you tend to see that you're a flunky that couldn't make it elsewhere. So I think it's just the negative stereotypes that they attach to certain field of law.
Did you want to say something?
Just very quickly, the question of race and class is really crucial to take up. I think it's always helpful to not have it framed in a way that suggests that the class question is embodied in whiteness. That's to say, when I heard, for example, Luz's comments, it's hard to understand those comments as not comments that's deeply ingrained in a class analysis. To go to Compton, for example, is to go to a place within which working class poor people live. And the fact that they're racialized, non-white, shouldn't belie that class analysis. The other thing I will say, which echoes to some extent Angela's point, is that, so at UCLA, we have formal affirmative action based on class, both at the undergraduate level and certainly at the law school. And it's exactly the same dynamic where when we think about how students are doing, it's not working class white students whose competence is called into question, it's necessarily students of color. Now, I don't think that means, therefore, that we shouldn't be concerned about the intersection of whiteness and class as it pertains to racial inequality. And I think if I would follow the literature, I would say that we don't engage in that question as robustly as we might. But I think the oppositional framing between race and class, or the framing that implicitly locates class in white bodies, I think is something that we should explore.
Okay, we have to end. I'm really sorry. We're already 10 minutes over. please carry on this conversation outside our doors, outside these doors. Thank you.